on the Senate floor today, but you don't know how that might be interpreted in a time of national emergency. I'm not I'm not predicting that it will. I'm saying we should have the certainty that it will not.
The senator has consumed 5 minutes.
Okay. Similar concerns also revolve around the definitions in terms of the applicability for the United States citizens and lawful resident aliens when you go to the word requirement does not extend. What about an option? These are the types of concerns I have. We should have language that very clearly makes everyone understand the conditions under which we would be using the United States military inside the borders of the United States. I yield the floor.
Senator from Michigan has 4 minutes.
Okay. Want me to yield now, or you want to yield to one of your?
Why don't we do one? Unanimous consent. Yield 2 minutes to the senator from New Hampshire, followed by the time from Senator Levin for the senator from Connecticut, and then what time I have remaining for the senator from Georgia.
Without objection, senator from New Hampshire.
Thank you, Mr. President. I first of all want to thank Chairman Levin and Ranking Member McCain and remind everyone that this particular amendment addressing the detainee provisions passed overwhelmingly on a bipartisan basis from the Armed Services Committee. And the reason that we addressed this issue was because we heard witness after witness in a series of months before the Armed Services Committee from our Department of Defense tell us, for example, when I asked the Commander of Africa Command saying he needs some lawyerly help on how to answer what to do with a member of al-Qaeda who was captured in Africa. This is an area that cried out for clarification, and that's the genesis of this amendment, which is a very, very important amendment. Just briefly, 2 issues. Number 1, on 1031. The arguments that have been raised about 1031, the statement of authority, this is a red herring. This provision was drafted, as Senator Levin said very clearly, based upon what the administration wanted and also really codifies existing law on what the statement authority is in terms of the fact that we are at war with al-Qaeda. And if people want to disagree with that, that's certainly a policy discussion that we can have. But we were attacked on our soil in 9/11, and this codifies the fact that we are at war with members of al-Qaeda. 1032 is the military custody provision. Let's be clear on what it does and it doesn't do. Number 1, it's very clear on who it applies to. It only applies to members of al-Qaeda or an associated force who are planning or carrying out an attack or attempted attack against the United States or its coalition partners. It does not apply to American citizens. We're only saying that if you're a member of al-Qaeda and you want to attack the United States, we're going to hold you in military custody. Why? I prosecuted cases in the criminal system. We don't.
Senator's 2 minutes have expired.
I would just say we don't want to ever have to read a terrorist and tell him you have the right to remain silent. That's the issue here. Thank you, Mr. President.
Senator from Michigan.
3 minutes to the senator from Connecticut.
Senator from Connecticut.
I thank the chair and I thank my friend, the chairman of the Armed Services Committee. Mr. President, I rise respectfully to oppose the amendment that the senator from Colorado has offered, though in some measure I thank him for offering it, because this has been an important and good debate. My own position stated briefly on this is that, as Senator Levin has said, we're a nation at war. And as such, we were attacked on 9/11/01. We adopted in this chamber the authorization for the use of military force. That's about as close to a declaration of war as we've done since the Second World War. And the comparison is not is exact, because what happened to us on 9/11 was in some ways even worse than what happened in December of '41 when we were attacked at Pearl Harbor. A nation at war that seizes those who have declared themselves to be part of enemy forces and have attempted to attack the American people or America should be treated as enemy combatants, as prisoners of war, according to the law of war. To me, that's just a matter of principle. Regardless of what statistics one could cite about how well prosecutions have gone in Article III courts, that's, to me, not ultimately the point. If we're at war, the people who are fighting against us ought to be treated as prisoners of war. In fact, we are without a policy now, as Senator Ayotte said, and one of the main reason I oppose what Senator Udall is proposing here is that he would remove the sections of the current bill that create a policy and send us back to where we are now, where our forces in the field don't know what to do if they capture a member of al-Qaeda. Mr. President, if I had my way, the provisions in this proposal on detainees would not have the waivers that the President has, would simply say if you're apprehended, if you're a foreign member of al-Qaeda and you're captured planning or executing attacks against Americans or our allies in this war, you are put in military custody and you're tried at a military tribunal. This is not the law of the jungle. This is according to American law. These are the same courts in which American soldiers are tried when charges are brought against them. And, of course, we accept and abide by all the provisions of the Geneva Convention. But that was not the will of the Armed Services Committee. The Armed Services Committee, in a good, reasonable, bipartisan compromise, has created a system here where the default position, the initial position, is to transfer these enemy combatants to military custody. It's a good compromise. It's the kind of compromise that
Senators, 3 minutes have expired.
That doesn't happen around here enough. I didn't get everything I wanted out of it, but it's a lot better than the status quo, and therefore I support the language in the bill and oppose the Udall amendment. I thank the Chair and yield the floor.
Mr. President.
Senator from Georgia.
Mr. President, I first ask unanimous consent that Debbie Shaw, a fellow in Senator Coburn's office, be granted floor privileges during the consideration of S.1867.
Without objection.
Mr. President, I rise today to urge my colleagues to oppose the Udall amendment, which would eliminate the bipartisan detainee provision that the chairman, the ranking member, and committee members worked so hard to craft. These provisions are necessary to provide some certainty for our intelligence professionals in how our government will handle terrorist detainees and how long detainees can be questioned for intelligence gathering purposes. We've heard quite a lot in the past few days from administration officials about how our intelligence and law enforcement professionals need flexibility. In fact, the Director of National Intelligence, Clapper, wrote to the Intelligence Committee arguing for flexibility and stressing the need for a process that, as he said, encourages intelligence collection through the preservation of all lawful avenues of detention and interrogation. With that, I agree wholeheartedly. The problem with the status quo, however, is that the administration refuses to use all of its lawful avenues of detention and interrogation available to it, choosing instead only to use one, and that's Article III courts. For nearly 3 years, members of Congress have pressed the administration to establish an effective and unambiguous long-term detention policy, but they have refused. The intent behind these bipartisan provisions is simple. We must hold detainees for as long as it takes to gather information our intelligence and law enforcement professionals need to take down terrorist networks and to stop attacks. Frankly, the best place, in my opinion, for this is Guantanamo Bay. But when it comes to Gitmo, the administration is no longer concerned about flexibility. Instead, we hear that Guantanamo is off the table. In fact, in a hearing when I asked the current Secretary of Defense prior to the SEAL Team 6 takedown of Osama bin Laden, if you captured him, what would you do with him? And he quizzically looked back and said, well, I guess we'd send him to Guantanamo. Well, we know that wouldn't have happened had we not taken him down. This is unfortunate because intelligence and law enforcement professionals, including some at high levels in the administration, acknowledge privately that what really hampers intelligence collection from detainees is the administration's unwillingness to take new detainees to Guantanamo for questioning. When our operators overseas are unsure about where they would hold captured detainees, it causes delay, sometimes missed opportunities, and sometimes
The time
capture
for the senator from
operations
Arizona has expired.
become kill operations. Mr. President, I urge a no vote on the Udall amendment.
Mr. President.
Senator from Arizona.
Mr. President, I'd like to thank all of my colleagues who have engaged in, I think, a very important debate. I would also like to say to my friend from Michigan, the chairman, I have observed him for many years debate various issues on the floor of the Senate and in the Armed Services Committee. I have never seen him more eloquent than I have observed in his statements today and throughout this debate. I also appreciate the fact that there are many in his conference who do not agree with the position taken by the chairman, and I especially am admiring of that. I think that where we are, I would ask the chairman.
3 more minutes.
Oh, how much? Anyway, okay, then I'll yield.
How much time is remaining, Mr. President?
Senator from Michigan has 45 seconds. Senator from Colorado has 1 minute.
Do you want to?
Senator from Colorado be allowed
He only needs 2 minutes.
2 minutes at least.
Without objection,
Such
Senator
time
from
as you
Colorado.
think.
I thank, again, the ranking member, the chairman of the Senate Armed Services Committee for their hard work. I want to just close with a couple of points. I wanted to, in the interest of clarifying the record, point out on the heels of the chairman's comments about the Statement of Administration Policy when it comes to Section 1031 that the full statement there read, because the authorities codified in this section already exist, the administration does not believe codification is necessary and poses some risk. After a decade of settled jurisprudence on the detention authority, Congress must be careful not to open a whole new series of legal questions that will distract from our efforts to protect the country. Second, Mr. President, there are questions that continue to be raised. I want to mention the Section 1033. The chairman said that it's only 1032 that really is the focus of our attention, but there have been questions raised about 1033. There's language in 1033 that makes it clear that we think it makes it clear that there's a provision that requires any receiving country has taken actions to ensure that the detainee cannot engage in any terrorist activity. This is if we're releasing or transferring somebody who's detained. I was in Afghanistan recently at Bagram Prison. We have 20,000 detainees there. There are some that believe 1033 would restrict us from releasing those prisoners at Bagram as we begin to draw down our efforts in Afghanistan. Just one of the many questions that are asked. Finally, I listened to the passion that my friend from South Carolina, Senator Graham, exhibited on the floor. We are all in this together. We are going to prevail. The bad guys in the world are not going to win. We do have, however, and that's what makes our country strong, different points of view on how we prosecute this war. And I believe that the intent of what's being suggested in these provisions is well and good and at the highest level. But there are many people we trust and respect, including the FBI Director, the Secretary of Defense, the Secretary of Homeland Security, the FBI Director, who believe that what will happen if you interpret the language will not actually reflect what our intent is. Therefore, let's set this aside, pass the NDAA, send it to the President, take the next 90 days to hold hearings, thoroughly vet what's in this set of provisions. I'll be the first person to come to the floor if all of those individuals and our own experts here tell us this is the right way to proceed, to say let's put this into the law. But let's not rush to take these steps. We've got something that's working. We have over 300 terrorists who've been prosecuted through our civil system who are in jail, many of them for life sentences that will outlast their lifespans. Let's not fix something that isn't broken until we really understand what the consequences are. And I thank again, my colleagues on the Senate Armed Services Committee, this has been a helpful and important debate. I yield the floor.
The senator from Michigan.
Also thank our friend from Colorado for his contribution to the committee. He is a valuable member of our committee, and he is no less valuable because he's offering an amendment which I happen to disagree with. Two quick factual points. One is that the language that the senator mentioned from Section 1033 is exactly the same language as was in last year's bill and is in current law. The only difference is we have given greater flexibility this year to the President by making it waivable. So our language is more flexible than the current law. Finally, in terms of the Hamdi case, the senator is correct. I believe it was Senator Udall said that this was an American citizen who was captured in Afghanistan, and that is true. But the Supreme Court in Hamdi relied on the Kieran case, which was an American citizen captured in Rhode Island, and quoted that case with approval when saying there's no bar to this nation's holding one of its own citizens as an enemy combatant. That was the Kieran language, American citizen captured in Long Island. If I have any time left, I would yield it and yield the floor.
Mr. President.
Senator from Arizona.
Mr. President, pending amendment is the Udall amendment, and am I correct, I asked the chairman, in that we would intend, depending on there's several things that have to be resolved, but we would intend to have this vote around 2:15 if things work out. Is that correct?
The senator from Utah also heard that, I believe, and I think it is all of our intention that we vote on this as soon as possible after 2:15. I think yield the floor and
Note the absence of quorum. Hang on.
The clerk will call a roll.
Mr. Akaka. Mr. Alexander. Zayat. Mr. Alexander.
Mr. President,
Senator from Arizona.
I ask the quorum call be suspended.
Without objection.
I ask consent that the pending McCain amendments 1230 and 1281 be modified with changes at the desk.
Without objection.
And
Mr. President.
Under the previous order, the Senate stands in recess until 2:15 p.m.
So as you heard, lawmakers are taking a break now to attend their party caucus lunches. An article from CQ helps to